Assalamualaikum warahmatullahi wabarakatuh. I am Adam Hakimi bin Muhammad Fadli, metric number 2319469. I will be discussing the expulsion of MPs, a presentation by Adam Hakimi Muhammad Fadli 2319469. The question that have been posed to us, or the drama that we have today, reads like this. Tan Sri Baru, Datuk Sri Buruk, and Datuk Baba are members of parliament who won their seats during the recent general election. Tan Sri Baru is a minister in the cabinet in charge of legal affairs. He criticized the president of his party, who is the current prime minister, for not being brave enough to combat corruption among members of his party. In a special meeting of the party later, it was decided that Tan Sri Baru was stripped of his membership and was no longer a member of his party. The Prime Minister also announced that Tan Sri Baru has been removed from the cabinet and no longer holds the position of minister. Tan Sri Baru claimed that the decision is unfair and arbitrary because he was not allowed to defend himself. Furthermore, he believes the Prime Minister, who is the president of the party, must respect his right to free speech and to criticize the party leadership. Datuk Seri Buruk, a member of an opposition party, has been expelled from his party. He then forms a new party and becomes the president of the party. Datuk Bapa, on the other hand, an independent member of parliament, pledges support to the current prime minister. The Speaker of Dewan Rakyat then declared that Tan Sri Baru and Datuk Seri Borok cease to be members of the House, that their seats shall become vacant because they have changed party after being elected as MP. Tan Sri Baru and Datuk Seri Borok object to the declaration made by the Speaker and argue that their rights to be members of a political party have been deprived. Tan Sri Baru and Datuk Seri Borok demanded that the Speaker declare the seat of Datuk Baba vacant because he should also cease to be a member of parliament. However, the Speaker refused to do so. Then, that Tan Sri Baru and Datuk Seri Buruk bring legal action against the Speaker in court to compel the Speaker to declare that Datuk Baba has ceased to be a member of Parliament, discuss the situation from constitutional law and human rights perspective. Moving on to the first issue is whether Tan Sri Baru's contention that his right to free speech has been curtailed has any merit at all. Firstly, we must remember that in the case of Tan Sri Baru, he contends that his expulsion from his party was not fair, was arbitrary, and against his freedom of speech. All right, moving on. Moving on, uh, the provisions referred to in the first issue is Article 10. So the rights that are important in this case under Article 10 is firstly 1A, freedom of speech, secondly, freedom of association, thirdly, 2A, restriction of freedom of speech, and 3A, a political party is bound by Article 49A. Other relevant provision is Article 49A, which gives the right for a member of political party to be expelled from the House of Parliament if he resigns or ceases to be a member of a political party. And secondly, the Societies Act 1966 that governs any societies, including political parties, in disputes. The cases we referred is Khalik Mehtab 2023 and Datuk Pasumanikam and another against Agnes Joseph. So in Khalik Mehtab, a member of a political party can be expelled as held. The two members of a political party, PKR, has been expelled, and due to this, um, They were expelled from the state legislative assembly. The fact of the case is that they pledged their support to Bersatu, and because of this, the PKR has the right to expel them from the party. In Datuk Pasumanikam and another, Raja Aslan Shah stated, as he then was, that in cases like this, where you have voluntarily entered into an agreement, that is, to enter an association, you are bound by the rules and regulation of that association, and that includes of um, the grounds of expulsion. So moving on. So we will be moving on to an application. So, the contention by Tan Sri Baru that he was wrongfully dismissed, and because of that wrongful dismissal, his freedom of speech was curtailed, was baseless because he had voluntarily entered into a political party, and thus he is bound by the rules, regulation, and constitution of the party, and assuming that the president of the political party of the prime minister has the authority to expel a member, and that the constitution gives the power for the president of his party to expel him from his political party. This does not, and any ground whatsoever, curtailed his freedom of speech because he had voluntarily entered into a political party which he is constitutionally and legally bound to follow. Secondly, we will be moving on to whether the expulsion of Tan Sri Baru from the party was valid. Moving on. So we will be referring to two sections, the Societies Act 1966, Section 18C, and also Section 40 of the same Act. Section 80C says that the decision of a political party is final, and Section 40 says that any dispute must be solved within the party and cannot be referred to court. However, these rights are had, or can we say have, its exceptions and its limitations, which can be seen in the case of Khalid Mehtab. In Khalid Mehtab, the court said that a person must first appeal the decision of expulsion to the working committee of a political party. In that case, two members of PKR has been expelled, and because of the expulsion, they lost their seat, and because of that, they brought an action to court, and because of that, the court said that you should have first appealed your expulsion. If your expulsion has been retained and there is issues, then you can bring it to court, and that issue is natural justice issues as expounded under Datuk Pasummanikam and another against Agnes Joseph. In that case, the court held that to first go to court, you must prove that a natural justice has been um, pushed aside. In that case, the fact of the case is that a member of MIC was not given an invitation to an annual general meeting, which she, as a member, has the right to. And this is against the rules and regulation. However, she should have gone to the working committee and appealed to the working committee before going to court. This, the court says, means that your contention, your action to this court cannot be justiciable. The court says categorically only in cases where natural justice has been grossly affected, then the court can interfere. To apply in the case of Tan Sri Baru, we see in the facts of the case, he was expelled by a special meeting. And secondly, he was not given the right to defend himself. Natural justice posits two rights. Firstly, that you have the right to be heard. And secondly, you have the right to be told of the charges that you have been charged with. Both have not been given, as he did not even have the chance to defend himself. Thus, it could be said that in Tan Sri Baru's case, his expulsion from the political party is clearly against natural justice. And because of this, the expulsion was not valid. The third issue is whether Tan Sri Baru, Datuk Sri Buruk, and Datuk Baba should or should not, based on points of law, be vacated from their seats. Moving on to the other slide, referring to Article 49A, a member of you may cease to be a member of parliament only on two grounds, which then is divided into a few a few sub paragraphs. Firstly, if you have been elected as a member of House of Parliament based on a ticket of political party, if you resign the party or ceases to be the member of the political party, you shall cease to be a member of Parliament. Secondly, if you are an independent member of Parliament and you entered into a political party, then you shall cease to hold that seat. And in this clause, it is stated clearly an expulsion is not a grounds of a ceasing of a membership of the House of Parliament. This will be important to the discussion today. And thirdly, which will we will refer back in issue 4, that a speaker shall, under his authority, determine whether a casual vacancy have existed upon written notice of a member of parliament. The cases referred to in this situation is firstly Ronald Kiandi and another and Datuk Johari bin Abdul. In that case, the member of PPPM was not removed as they ceased to be members of Bersatu before the general election. Thus, merely pledging support does not um, cause the cessation of their tenure. In that case, referring back to our case right now, the four members of Bersatu has been declared to cease as members of their political party outside of the GE15 parliament tenure, and because of that, they had not ceased to be members of parliament. In Khalid Mehtab 2023, the court held that again the members of PKR that joined Bersatu after the expulsion from PKR was removed from Parliament, from State Legislative Assembly. However, the court differentiated this with Article 49A because they said that Article 49A does not give expulsion as a grounds for removal. Similarly, in Khalid Mehtab 2024, the first and second plaintiff was held to still be members of parliament because they merely contested under PKR logo and not PKR members per se. So they are merely pledging support for a different political party is not grounds for dismissal. In the same case, the court again refers to Article 49A, and now with the handset available states that the handset clearly provides the expulsion of members of political party is not grounds for removal for members of parliament. To apply, in the case of Tan Sri Baru should not have been removed from office as it is clear by the language of the Constitution that expulsion shall not be a ground for removal or vacation of a seat of parliament. For Datuk Sri Buruk, he should not have been removed from office because, in his case, it is a clear gray area or a loophole or as lacuna in the Constitution that if a member is independent and then entered into a party, he shall cease to be a member of parliament. However, Datuk Seri Buruk has been expelled after being elected as a member of a political party, thus does not fall under Article 49A1 A2 because he was not elected as an independent member of parliament. He was elected as a member of a political party, and his expulsion from that political party was not grounds for expulsion from the House of Parliament. In the case of Dato Baba, he merely pledges support to the Prime Minister. He does not, in any way or form, fall under the provisions of the 49A. He is not entering into a political party. He is not a member of a political party who resigns. He merely, as an independent, pledges support to the Prime Minister. Thus, in his case, the contention by Tan Sri Baru and Datuk Seri Buruk has no merit whatsoever. He should not, and there is no basis of law for him to be removed. In conclusion, all three of them are still members of parliament based on law. If we are talking just about the substantiality of the law. Sorry for the wrong wording. So in this case, whether the decision to remove Tan Sri Baru and Datuk Sri Buruk by the Speaker was justiciable. Moving on. Generally, any proceedings within the House of Parliament and also the State Legislative Assembly is protected from any proceedings of court. Any decision is protected and is not justiciable. This is provided under Article 63(1) of the Federal Constitution that gives privileges of Parliament. Reading verbatim, the validity of any proceedings in either House of Parliament or any committee thereof shall not be questioned in any court. This is pari materia to Article 72, Clause 1, that gave the same right to the legislative assemblies of the Federation under all of its states. The case we referred to is the case of Ronald Kiandi and another against Datuk Sri Johari bin Abdul. This decision is important. This case is important because in that case, the court the find that clearly the decision of a speaker is not justiciable um, unless he is not justiciable because in that court, in that case, both all of them has ceased to be members of Bersatu. The speaker merely decided does this secession of a member of a political party uh, cause the secession or vacancy of the seat of the House of Parliament. In Khalid Mehtab 2023, um, the court held that the expulsion of the second and the third member, the second and the third and the fourth plaintiff was not justiciable because they were truly expelled from the party, and thus the speaker has the jurisdiction and authority to adjudicate whether a secession of a membership of parliament, membership of state legislative assembly have existed. Differentiating to Khalid Mehtab 2024, in the case of Khalid Mehtab 2024, the court clearly states that the first and second plaintiff is members of Bersatu. They are not expelled from Bersatu. They merely contended under PKR, and they had not ceased or being expelled from PKR. So because of that, the speaker has overbound his jurisdiction to declare or to adjudicate that a cessation of membership of the state legislative assembly has occurred. And this decision is based on the case of Teng Chang Kim, in which the court says that the decision of a legislative body proceeding is justiciable if the legislature had overbound its jurisdiction. So, in the case of Tan Sri Baru, the decision to declare that he was no longer a member of parliament is not justiciable because the provision of the law under the federal constitution is very clear that an expulsion of a member of parliament, uh, the cessation of membership of parliament can only occur if he had resigned from his political party or he had um, ceased to be members of the political party. In this case, he was expelled, and expulsion has been clearly protected under the law. Thus, the Speaker has no jurisdiction whatsoever to adjudicate on the matter of expulsion, because expulsion is not a grounds for cessation of House of Parliament. So a casual vacancy has not occurred, and because a casual vacancy has not occurred, he could not adjudicate on the matter. But if, hypothetically speaking, he was he had resigned, Tan Sri Baru had resigned from his office, and a casual vacancy had been reported by a written notice, then he has the authority to declare whether a casual vacancy has occurred or not. And if he declared that a casual vacancy had not yet occurred, then and only then that decision would not be justiciable because he has not overbound his jurisdiction. Similarly, in the case of Datuk Sri Buruk has entered into a political party. However, he was not an elected independent. He was elected as a member of a political party. Thus, that is not a ground for casual vacancy. And because casual vacancy has not yet occurred, again, the speaker has no jurisdiction whatsoever to determine whether a cessation of membership of parliament has existed, and because of this, he had overbound his authority as a speaker. So to conclude, the speaker decision was not just legally wrong, but justiciable and should be held by the court to be wrong, and thus the decision could be overturned by the court. With that, I end my presentation and thank you for listening.